Good evening, everyone, and thanks for joining us. It is Tuesday, and it is the 14th, and this is going to be one of those programs where you'll be seeing more news than myself. I left Sagersville at 8 o'clock this morning in an effort to make sure I was on time for today's appeals court hearing as it pertains to the McGoffin County Judge Executive's race, and only made it back into the studio shortly after 4 o'clock. A lot of the news and information you'll see tonight will be raw and unedited to some degree, and there will also be some other headlines that we'll cover. We'll also have some exclusive interviews from all three parties, that being from the Board of Elections, the Judge Executive, and John Montgomery, or representatives thereof, following testimony presented before a three-judge panel of the Kentucky Court of Appeals, of which I'll be bringing you as much testimony as tonight's program will allow, but enough to give you a good idea as to what was presented before the three-judge panel, as well as what kind of questions they may have had for the parties involved. Before we get to that headline, which will actually consist of two different segments, there has been some other news to take place here in Sagersville, McGoffin County, and in the surrounding area since I saw you last, beginning with a stabbing that I'm told unofficially took place at or near a Sagersville business sometime around midnight last night. We know that radio traffic indicated that police responded to a scene and then called for medical response in regards to a stabbing. Now, they were near a Sagersville business in the Sagersville downtown area. However, it appears as though the original altercation and even maybe the stabbing took place at a Sagersville residence. What we know is that this Michigan man is still lodged in the Big Sandy Regional Detention Center, facing charges for seriously injuring after stabbing an individual twice in his back, a McGoffin County man who appears to be able to survive from his injuries. Ralph Edward Enix, this man and an Eric Fletcher reportedly got into an altercation, and at some point Enix stabbed Fletcher in a driveway somewhere in the Sagersville area. We understand that he received two stab wounds, both to the back, one of which hit a lung and then caused serious and immediate complications. All we know about Enix is that he is from Woodhaven, Michigan. The 38-year-old has been charged with first-degree assault, still lodged in the Big Sandy Regional Detention Center. The next two headlines are both weather-related, and after picking up what is now almost 2.5 inches of rainfall for this most recent rain event today and last night, more flooding and other problems have resulted all over Kentucky, not just in eastern Kentucky, but all over the state. And we've got much more to come, I'm afraid, much more to come possibly. But we'll talk about your weather forecast in just a few moments. These are some photographs I received today on the road from a viewer, Tammy Lynn Gibson, who sent these photographs of her vehicle as it was no longer on the roadway on Jim Arnett Branch in McGoffin County. In her message to us here at the studio, she says the road crumbled underneath her, and then her vehicle slipped off of the roadway and into the flood-swollen ditch. If you want to phrase it that way, I suppose will be correct. She says she was both frightened and heartbroken at the same time after losing her vehicle, which she says is now, of course, totaled as a result of the water damage. She also credits a neighbor for pulling her from the vehicle and to safety. This was on Jim Arnett Branch in McGoffin County. As far as road conditions and other details for this story, like the story I just brought to you about the stabbing and the next weather-related story coming up in just a second, I'll have more details on tomorrow night's program when indeed time allows. We do believe Miss Gibson is okay, but we'll be following up on exactly how the accident happened with more details at a later time. And check these photographs out. This is a slide. Slip is a awful light term to use, but a slide that has taken place in McGoffin County, and I'll talk more about where the pictures were taken and who took them tomorrow, but I can tell you right now that it happened on Meredith Fork. That is on the right-hand fork of Punchin off of Route 7. While the earth slide blocked the roadway, it also left a McGoffin County residence hanging on literally. I'm told the distance between the porch or the home and the edge of the bank may be measured as 10 feet or even less. You can see homeowners there on the porch overlooking the situation, which indeed still has the potential to worsen with all of that earth loosened by all of the rainfall, and yet more to come. I'm told an area resident used a private piece of heavy equipment to clear the roadway and allow residents to travel Meredith Fork. But we also understand that there could possibly be, as I said, more situations just like this during the overnight. And, of course, this area is certainly one for concern and one to keep an eye on. For now, be sure and keep an eye on the rest of the program. We'll begin with appeals court coverage in just a few moments after a word from some of our sponsors. Be sure at every opportunity and let them know you're watching. I'll be right back. To get high-speed internet on their state-of-the-art fiber optic network for all of your home and business solutions, or to watch TV without a contract on over 200 digital channels with superb quality, or stay connected with family and friends with 24/7 telephone service you can always depend on, contact Foothills Broadband today. Or just click on their link to the right to find out how they're working to provide the latest in communications at affordable prices with exceptional service at Foothills Broadband. One election, three separate appeals. The question put before the Court of Appeals case on behalf of Charles Doc Harden to vacate the decision handed down by Special Appointed Judge John David Preston, vacating him from office. He, of course, was allowed to stay in office after filling out a bond until the appeals court hearing. Also, the Magoffin County Board of Elections appealing the same decision, while John Montgomery, who would have been declared to some degree a victor, seeing the office vacated, also filed a cross appeal asking that Preston's decision be enhanced and he still be declared the victor of what he says was an unfair election due to widespread fraud in Magoffin County. The first to speak before the three-judge panel was Mark Flores, the attorney representing John Montgomery of Magoffin County.
Ballots are different standards, and perhaps that's where the confusion comes in. Under the standard with regards to the substantial compliance, as Your Honor has already alluded to, in Arnett v. Hensley, Reagan v. Burnett, and a number of cases regarding absentee ballots, the standard is if there is substantial compliance with the absentee statutes and proper ends are reached in the counting and casting of those absentee ballots, then those are okay. However, if there's not substantial compliance with the statute or improper ends are reached, then the entirety of the absentee ballots should be discarded, allowing for the remainder of the legal votes that were cast on election day at the precincts to be counted, in which case this would adjudge Mr. Montgomery the winner.
Okay, now there's testimony according to the judgment, I haven't seen it yet, that there are approximately 3,000 union members who are out of the county and vote absentee quite often and vote Democratic.
Your Honor, the way that testimony came about was just sort of that, what would be a plausible explanation for this potential extraordinary amount of absentee ballots?
Wait, now, is it extraordinarily, if you compare it to 2010, what's it, an extra 150 votes?
Perhaps, Your Honor, but the real comparison that needs to take place is between 2014, when this election happened, and 2013, 2012, 2011, where the numbers were not nearly as extraordinary. Rather, this seems to happen every 4 years. And in particular, the election that you just referred to, Your Honor, was one that did involve Dr. Hart.
Is there proof in the record about the absentee ballots at the presidential election?
Your Honor, I believe that there was some testimony with regards to that.
What was the amount proved in the record?
It was substantially lower.
How does this compare to surrounding counties?
Well, when you take a look at the surrounding counties, again, the numbers are just extraordinary. This was actually in the record, and you can see the testimony in video record number 1, 25516 by Kim Jeviden. Magoffin County had more than 2 times the amount of absentee votes than that of Floyd and Johnson County combined, despite the fact that Floyd and Johnson have 3 times the amount of eligible voters as Magoffin County. Magoffin County as well had more than all other eastern Kentucky counties by double. And along with that, Magoffin County had more absentee votes cast than Pike and Floyd County combined.
So let me ask you a question.
Yes.
We saw there 2 competing forensic examiners discuss signatures.
Yes, Your Honor.
You're discussing the extraordinary number of absentee ballots. Did you find any one voter who said, that's not my signature? Or did you find any one voter who said, I didn't vote absentee? Or did you find any one absentee vote that was in the cemetery? Did you have any proof of any specific fraud?
Your Honor, we did not have any proof of specific fraud, but part of the reason for that is that no fraud is required to be shown in seeking the remedy to discard the
So it
absentee
would
ballots.
certainly help your case. You looked for it, didn't you?
Well, and I think that the evidence of fraud is specifically set forth in the numbers. In addition, we did have one voter as well who did admit to having his vote bought. But if you take a look at the numbers themselves, they're extraordinary.
The voter, the mentally challenged voter that said, he said it was bought?
Your Honor,
He had said it to somebody else at the minute mark. He didn't say it under oath, did he?
well, actually, Your Honor, this was a separate voter. This was Jerry Adams, who gives his testimony at video record number 2/11/28/47.
What did he say he was paid?
He said he was paid $25 to cast a vote for Dr. Harding.
The clerk was going through the absentee ballots and why the statute is as it is, and I don't believe you were able to finish that. That part of the record concerns me. Could you explain that to me a little better, please?
Well, Your Honor, I think it's clear that at least 11, there's 11 statutes that make up the absentee balloting scheme. I've identified and we have proven 5 different violations, and these are all admitted violations through the testimony of the court. As I stated before, the first one was a constitutional violation, as well as a regulatory violation with a secret ballot issue. People could hear how people were voting. If that doesn't concern this court, it's hard-pressed not to concern. And for no other reason, if you can hear how somebody votes, it's a lot easier to pay somebody for that vote that they cast. Again, the absentee ballot applications, the way that somebody gets the ballot in the first place, there are at least 3 to 4 violations of that with regards to...
Let me interrupt you
Yes,
just a
please.
second there. With the absentee ballot application, it comes into the clerk's office and it doesn't have the social security number on it. And your position is that does not meet the statutory requirement to have the privilege to use the absentee process?
Yes, my position is that whatever the State Board of Elections put on the form to be required is required, regardless of whether or not the McGoffin County clerk decided all of a sudden that they need to, that it's not required based on a statement that may or may not have been made by the State Board of Elections, as we've already stated they weren't there. That's part there. However, what is expressly required is that the location of where somebody's going to be on election day is stated there, regardless of whatever excuse they come up with. That is expressly required. And it goes back to the reasoning behind absentee ballot voting. It's a privilege. It's something that's only accorded in certain circumstances. And the minute people start taking shortcuts, which is what happened here, for whatever reason might be, then all of a sudden that privilege turns into a major problem. Because McGoffin County may take this shortcut, but what's to say that the next county doesn't do the same?
As I understand Judge Preston's findings of facts, and I've been through them several times, the problem lies in the absentee ballots. The machine vote had your client up by 400 plus votes or something like that.
Yes, Judge.
It wasn't until the absentees was in fact counted. So I guess what and you've got a cross appeal here too, and I think perhaps now's the time to talk about that. You're asking that the absentees just be thrown out, totally.
That's correct, Judge Mays. And in fact,
Do you have any authority for that?
absolutely. If Your Honor would refer to the brief, we've actually cited, I believe, at least 8 different cases where
We have
that...
Judge Cunningham's recent opinion. I mean, that's not what Judge Preston recommended, though.
That isn't what Judge Preston recommended. And in fact, it goes to the standard review of this case in general.
Exactly. And that's where I'm going.
Exactly, which is that this court, while limited to a clearly erroneous standard with regards to the findings of fact, is however allowed to make a de novo review.
Next to address the court was Bud Eldred Adams, the attorney representing McGoffin County Judge Executive Charles Hardin.
I know it's a good bit of time, but that summarizes the key points on 4 days of trial. And that we did that because there's no evidence of any wrongdoing. Going specifically to the page 48, paragraph 51 of the trial court's findings of fact. It says the court finds in the absence 4 voters, Jerry Adams, Simon Marshall, Doug Marshall, Brian Marshall, cast ballots as though being paid or expected to do so. Then, first place, Mr. Adams was very, shall we say, mentally challenged. He gave about 4 different versions of what actually happened that day. And on the $25, there's confusion of whether it was for a vote or whether it was for some junk that he and his cousin had sold. Now the key to this would have been the man who brought him to the polls, Jason Holland, his cousin. As far as I know, Jason Holland was never subpoenaed as a witness in this case. Never. And that's the one person that could have set that very straight. Simon Marshall, extremely challenged. On Simon Marshall, he didn't even say who he voted for. We don't know if he voted for Dr. Hardin or Mr. Montgomery. Didn't even vote in that race. And he denied he even sold his vote. That's just a supposition of the judge. Then we go on to Doug Marshall and Brian Marshall. I honestly don't know how Judge Preston reached that result because those gentlemen didn't even testify. And as far as I know, they were within the subpoena power of the court. They did not testify, and those are the ones that you would have had to have had testified. Instead, what they relied on was inadmissible hearsay. They relied on the hearsay testimony of Avonda Bailey and a Maxie Arnett. They tried to smuggle in testimony through those 2 witnesses. And Judge Preston repeatedly sustained our objections to the introduction of that evidence.
Ballot comes in, or the application for the ballot comes into the clerk's office. Mm-hmm. And if it does not have a social security number on it, and I'm not a county court clerk, nor have I ever sat through the opening of these ballots, nor have I processed this, so please educate me. If that comes in, doesn't it make sense that the social security number is there for the purpose of the clerk confirming that whoever has mailed this in is actually that person? And they can check that social security number in-house on their own books, or am I incorrect about that? Doesn't the clerk's office have your social security number on your voting record?
I truthfully don't know the answer to that, Your Honor. Mr. Nemus might be able to address that. But it came out in the testimony at the trial that, well, number one, 2 things is, number one, unless you fill in the required fields with the state election board, it won't print out a form.
And that gets to my point. It seems to me that it may be possible that it is the clerk's sole duty to confirm that in-house rather than there being a need to confirm it with Frankfurt. Is that possible? Was that developed in the testimony?
I don't remember it being specifically developed, Your Honor. I do remember one thing that did come out in the testimony is that they doing away with the Social Security requirement because of privacy concerns, and I think the county court clerk testified at maybe a meeting just before this that they had with election officials that requirement is being eliminated for privacy concerns.
You will concede, will you not, that it does have a place, the statute does require you to put where you're going to be on election day when you apply for absentee ballot.
It does say that, Your Honor, and our position is it was substantially complied with because there were 2 instances of that. One, if you're ill, it has your address. I think that is really substantial compliance. I think it would be directory, not mandatory. There's nothing in the statute that says the failure to fill out that box towards the election.
How about just leaving it blank?
Well, again, Your Honor, I think there's still substantial compliance with it. And also, I think I would view that really as directory rather than mandatory.
And lastly, Jason Neems, the attorney representing the McGoffin County Board of Elections.
Well, I wanted to answer the court's question on that, and that's pursuant to the State Board of Elections. Your Honor, disenfranchising voters and throwing out elections is not something we do in Kentucky unless the contestant proves flagrant extensive and corrupt violations of election laws. These violations must destroy, quote, in the quote of the Upton case, destroy any hope that the results as tabulated would be a fair indication of the sense of the voters, close quote. To respect both the rights of the individual voter and to protect the integrity of the system, Kentucky courts have required substantial compliance with Kentucky election law. So the question is whether these violations strike at the heart of the election and expose the election as a fraud. Before I get into the reasons why the contestant has woefully failed to meet that burden, I want to say a couple words about process, because it's extremely important. As this court knows, Kentucky courts have no jurisdiction to hear election contests but that which is given by the General Assembly. And the General Assembly has been clear. It has stated that you have 30 days to file an elections contest, and they filed on the 30-day. Fair game. But it also says that you have to try your case within 30 days of the last summons. They didn't do that here. They asked the court for more time. The court is supposed to give reason for the cause, show the cause for why they need more time. The court didn't do that. We object. But that's not a basis of our major objection. There's two reasons that the General Assembly has set that 30-day rule. One is to make sure that we're moving quickly, expeditiously. These are elections contests, after all, and that's very important. We need to move quickly. And this court has recognized that by setting an expedited briefing and oral argument schedule, and we thank you for that. But the other reason is to make sure that you know what you're talking about when you file your pleading. It's to stop gotcha games, ambushes. This case was an ambush. So KRS 120-165, the 30-day rule, is not the only statute on the book that matters. KRS 120-155 is just as important. And what it says is, when you submit your pleading 30 days after the election, you have to state your grounds. You can't change your grounds, and you can't amend your pleading. You can't add additional grounds. Well, that's what happened here. What happened here was, with respect to the absentee ballots, which later became the core of their case because their other ones just fell, their other case just fell apart. They totally changed it. At first, here's what it was. In paragraphs 69 and 71 of their pleading. In paragraph 69, what they say is, dead people and other ineligible people were allowed to vote absentee. They didn't list them in the pleading. So we asked Mr. Montgomery during his 15-hour deposition, give us some names. Who died? Who was ineligible? He gave us one name, E.J. Rudd. E.J. Rudd, thank the Lord, is alive and well today, and he was alive and well when he voted in the November 4th election. He gave us no other names. So his absentee ballot claim had fallen apart. He filed a placeholder complaint because he had to file it 30 days after the election, hoping his case would follow. His case didn't follow. He totally shifted. He pivoted. And when we brought that up to the court, opposing counsel relies on a statement in paragraph 71. And it says, quoting, the absentee votes in violation of KRS 117.075 to .088 and other votes cast in violation of election law, so forth and so on. That's citing 11 statutes with scores of subsections. Subsections of subsections.
There's another statute that says when the complaint's filed, it's a complaint of inequity. Is that your understanding?
Judge, I'm not aware of that statute that says it's a complaint of inequity. I am aware of KRS 120-155, which says you have to state your grounds and you can't change them.
There was also much rebuttal and further discussion. By and large, when a case is brought before the Court of Appeals, my understanding is just the information from the prior court's ruling. That information is examined and then a ruling is rendered. This, however, taking into consideration the extenuating circumstances and the gravity of this case, the court elected to have a public hearing in which the attorneys and parties were able to present their cases as they did in the previous trial. It lasted, instead of the customary 30 minutes, close to 2 hours. I'm going to make an effort to show you in its entirety at some point relatively soon. And also some exclusive interviews that I'll have to hold until tomorrow night. But I can tell you that they did adjourn. No timetable was given, except to say that they would take the matter into consideration and further examine materials which they have not had time to thoroughly examine that were only given to them last Friday.
Thank you very much.
Thanks, Your
I'd like to tell you all this. We haven't seen the hard copies of your briefs yet, but what we've read by email is excellent. Your arguments are excellent. Are there any further questions? No. All right. We can stand adjourned.
All right.
To get high-speed internet on their state-of-the-art fiber optic network for all of your home and business solutions, or to watch TV without a contract on over 200 digital channels with superb quality, or stay connected with family and friends with 24/7 telephone service you can always depend on, contact Foothills Broadband today. Or just click on their link to the right to find out how they're working to provide the latest in communications at affordable prices with exceptional service at Foothills Broadband. And once again, going back to coverage of the Court of Appeals case and hearing no decision made today, it is only assumed that it could be a week more or less. And of course, we'll be closely watching and monitoring the situation and have those exclusive interviews with either the parties or attorneys representing them on tomorrow night's program, and a whole lot of news that I perhaps may not even be able to get into what's left of the work week. Nevertheless, your Licking Valley RACC forecast is as follows. Low of 50, cloudy skies, rains ending by around 2 a.m., becoming light and scattered even at this time with 2.3 inches of rainfall here at the studio. Midweek tomorrow, 65, clouds, showers possible again, and a low of 50. We're going to continue to see showers and even a chance of storms throughout most of the forecast, and even that brief mention of sunshine that I had a little later on in the week has now since been nixed from the forecast. We'll see a chance of showers and temperatures hovering right around the low 70s after Wednesday and, well, even Thursday with the upper 60s considering that forecast. And then some cooler air on the backside of all of this rain with no real end to this pattern in the foreseeable future. For now, that's my time. Thank you for being a part of it. We'll see you back here tomorrow for another special edition, as they all are, of Your News Today. Good night and so much. Thank you so much for being a part of the show.